Hi there. Good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is, and welcome. I'm Larry Erickson. This is the Erickson Report. And we start this time, as I always like to, whenever we can, with some good news. I've actually got several bits gathered over the last few weeks. And first up is this is just feel-good news as far as I'm concerned. Sure, you remember the cyber ninjas, that outfit with the partisan roots and the shoddy practices that ran that lie-driven audit of the 2020 presidential count in Arizona. The count that, despite all of that, still showed that Biden won the state. Yeah, you remember. Well, now you can forget. The cyber ninjas are closing down. This follows a rebuttal from officials in Maricopa County who looked at which Maricopa County was where the fraudulent recount was taking place. And they looked at some 77 claims that the cyber ninjas made about the balloting and determined that 76 of them were either false or misleading. Then there was the fact that a county judge in Arizona was holding the company in contempt of court and ordering it to pay $50,000 a day in damages, in sanctions, I should say, for refusing to provide records regarding the so-called audit to the newspaper, the Arizona Republic. Because, folks, you know, karma can be a bitch. All right, next up, a bit of good news out of the United Kingdom. On October 17th, 2019, 3 members of the Christian Climate Action, an arm of Extinction Rebellion, blocked a train in London for over an hour during morning rush hour. The train was headed into the city's financial district, and the group said the protest was to symbolize how business as usual should not be allowed to go on, and that it was a proportionate response to the existential threat of climate change. The 3, Reverend Sue Parfitt, 79, Father Martin Newell, 54, and former university lecturer Phil Kingston, 85, were charged with violating the Malicious Damages Act, carrying a potential sentence of, if I read the act correctly, 2 years in prison. On January 14th, all 3 were acquitted. What's more, on the same day, Extinction Rebellion protester James Brown had his sentence cut from 12 months to 4 over his supergluing himself to the roof of a plane at London City Airport. And both of those events followed the December acquittal of 6 other Extinction Rebellion members who were charged with blocking a train during a similar action at Canary Wharf Station in April of 2019. That jury took less than an hour. It appears that at least the people, even if not the government of the United Kingdom, are recognizing climate change for the crisis that it is. Next up, anti-war and anti-hunger activists in Florida have won a 7-year legal battle against the city of Fort Lauderdale, which have been trying to prevent the local chapter of Food Not Bombs from giving free food to people in need at a local downtown park. Last August, a 3-judge panel of the U.S. Court of Appeals for the 11th Circuit unanimously ruled in favor of Bread Not Bombs, finding that the rule is unconstitutional as applied, and the city's requirement for a permit, which could cost as much as $6,000, can't qualify as a valid regulation of Food Not Bombs' First Amendment rights because it was utterly standardless. In other words, you could be denied for any reason or for no reason. On January 5th, Food Not Bombs announced they had reached a settlement with the city, under which the city admits it was wrong, pays the group a small amount of damages, and covers at least a significant part of, if not all, of the group's legal expenses. Now note the reason that Fort Lauderdale and other cities have tried and are continuing to try to impose bans like these comes down to one issue. They want to hide the issue of homelessness because they think it's too difficult or too inconvenient or whatever to try to do anything about it. All right, last March, Texas Governor Greg Abbott launched Operation Lone Star, deploying thousands of National Guardsmen, Texas Department of Public Safety cops, and other state officials and state resources to the border with Mexico, and gave them the authority to arrest suspected migrants under suspicion of criminal trespass on private or government property. One such person arrested is Jesus Alberto Guzman Carapoma, an engineer from Ecuador who hoped to submit a request for asylum. He was arrested in September at a railroad switching yard on a charge of criminal trespass. On January 13th, Travis County Judge Jan Seufer declared his arrest unconstitutional, making some immigration advocates hopeful the ruling could create a pathway for other migrants who had been arrested under this program. Guzman Coropoma's attorney successfully argued that that Operation Lone Star violates the supremacy clause of the U.S. Constitution, so that state laws are prohibited from interfering with immigration enforcement by the federal government. What makes this case remarkable is that the Travis County District Attorney's Office agreed. They were representing the state of Texas in this proceeding, and they agreed with the result. Travis County District Attorney Jose Garza said in a statement that the program is an impermissible attempt to intrude on federal immigration policy and has failed to satisfy basic, fundamental, and procedural state and federal constitutional safeguards. Now, a spokesperson for Governor Abattoir said they expect the ruling would be overturned because the judge couldn't issue that ruling without hearing from the Attorney General, which seems doubly weird to me. First, because I was unaware that a judge could not issue a ruling without first checking with Abattoir's administration. And I'm wondering how they're going to appeal when someone representing the state of Texas was at the hearing and agreed with the outcome. But that kind of thing has never stopped them before, so we'll have to see. Even so, this is still a win. All right, next, something I don't know if I can truly call good news for reasons I will try to make clear. But the news here is that Greg and Travis McMichael, two of the men convicted in the murder of Ahmaud Arbery, have been sentenced to life without parole. And the third, William Roddy Bryan, to life with parole only after 30 years. Now, I take satisfaction from this because it's an indication that maybe at long last, we as a society are taking racist murder more seriously. But the fact is I can't be entirely happy about this because of my conviction that our so-called criminal justice system is deeply screwed up. Which brings me to something that definitely is good news. Earlier this month, Manhattan District Attorney Alvin Bragg announced sweeping changes to the borough's criminal justice system. Among other changes, he said prosecutors should no longer seek prison sentences of over 30 years except in extraordinary circumstances, and he urged them to only pursue prison for the most serious offenses, looking instead to diversion and alternatives to incarceration. The idea is to shift away from pursuing lesser crimes like marijuana misdemeanors, prostitution, fare evasion, and instead focusing more on violent crimes like gun crimes and domestic violence. The Sentencing Project applauded these changes, noting it had previously recommended a 20-year cap on prison sentences, and noting that, quoting the group, virtually no other nation in the world routinely pursues extreme sentences beyond 20 years. The United States is a clear and appalling outlier. But of course, Bragg has faced extreme vituperation from the usual suspects, including right-wing grifters going on about bloodbaths, as well as cops, including City Police Commissioner Keechant Sewell, who sent an email to every member of the NYPD saying, "I am very concerned about the implications to your safety," or in other words, look out, the mayor's going to get you killed. Although I strongly suspect she's actually more fearful of the potential impact on her department's budget than she is on any potential impact on police safety. It remains to be seen how strong Bragg can be in the face of the vicious reactions, ones he surely should have seen coming. But at the very least, a marker has been laid down. This can be a notion of what defund the police can look like in practice, and that is indeed good news. All right, on another topic, it's sort of related to this, so I'm going to put it in here. On December 9th, Bigler Stouffer II, 79, was executed for murder at the state penitentiary in McAlester, Oklahoma. He had been convicted of the 1985 shooting death of one Linda Reeves, an incident that also left her boyfriend, Doug Ivins, seriously injured. He originally was convicted in 1986, but the conviction was overturned on the grounds that he had received inadequate representation. He was reconvicted in 2003, meaning he spent the last 35 years of his life on death row. Now, without going into details of competing assertions, I'll note that to the very end, to the very moment he entered the death chamber, Stouffer maintained he was innocent. As recently as a hearing before the Pardon and Parole Board in November, he insisted that Ivins was shot as the two men fought over a gun at Ivins' home and that Reeves was already dead when he arrived. Now, that board recommended that Stouffer's sentence be commuted to life without parole, but Governor Kevin Stitt rejected the idea, which is perhaps not surprising since attorneys for the state opposed any clemency, saying that Stouffer's, quote, heinous actions, his lies and manipulations, and his complete lack of sorrow and remorse for the hurt he caused should dictate one conclusion: the jury's death sentence must be carried out. Now, that last part of this is why I bring this up. Okay? There is a gaping hole at the center of our supposed criminal justice system, which reveals it to be in reality a prosecution procedure system. One where truth is not pursued, it is created. Something most markedly obvious in death penalty cases where finality takes on a literally lethal meaning. If you're convicted at trial, that becomes not just our best current societal judgment of the reality of the events involved. It becomes revealed truth, holy writ. And this finding of fact, whether by judge or jury, can't be challenged on appeal except under the most extraordinary circumstances. Only the legal technicalities of reaching that conclusion can be challenged. Not only must the courts accept your guilt as utter truth, so must you, to the point where absolute proof of your innocence of this crime may not save you unless that proof could not, note I said could not, was not, be presented at trial. In fact, just last month, the state of Arizona told the Supreme Court in oral arguments related to a case, Shin v. Ramirez, that, quote, innocence isn't enough here, unquote, to allow two men to challenge their convictions in federal court. And they were in fact preaching to the choir because the Supreme Court has said exactly that previously. And so we have Bigger Stouffer, who frankly may or may not have been guilty, I don't know, but who in either event encountered the fact, as so many others have, that continuing to insist on your innocence after you have been convicted will be used as a weapon against you in any attempt for any kind of mercy or understanding or justice. Because the system will admit we did it wrong, but will, you'll pardon the expression, fight to the death to avoid saying we got it wrong. The death penalty should simply disappear. And we are taking a break. And we are back. Okay, now what's next is the first installment of what promises to be a long series, when my intent is to be a part of every, or at least most every show. It's called The Threat. To start, I want to lay out what I mean by the term and the sort of things this series will cover. The thing is, we are faced with a wide variety of internal threats to our functioning as a free society. Threats driven by the reactionary right, which these days pretty much means the whole right. Threats pursued sometimes just in pursuit of just power, but sometimes with simply a desperate and pathetic attempt to keep the future from actually happening. There are, for example, threats to our ability to vote, coupled with moves to turn election administration and vote counting into a partisan enterprise. There are attacks on the right to abortion and on the rights and dignity of LGBTQ plus people, now particularly transgender people. There are attacks on our First Amendment rights related to the press, speech, and assembly. There are threats to our personal privacy, and those come as much from corporations as they do from government. Basic social services, particularly right now, the right to public education, are under attack. And of course, there is the overlying existential threat of climate change. The idea is that every show I will address and cover some news and commentary relating to one or more of these sorts of issues. And this time, as you might have been expecting, we're going to look at our right to vote. Now, before I go on, I'm going to say that what follows, I'm going to do as I originally prepared it, which was done before the disgraceful display of hypocrisy and hubris in the Senate. Even though the events of that day, that first day of debate, were not unexpected, still the event itself is the same. The feeling of the event is the same. It's like seeing two cars approaching each other at an angle, like on different, from crossing streets. And you see both of them speeding. You realize that neither one of these drivers sees the other. Neither one has any intention of stopping at this uncontrolled intersection. And you see this horrific crash coming, but that doesn't make the actual crash any less horrifying. I cannot begin to express the level of contempt that I have for Senators Fishface McConnell, Joe Mania, and Kirsten Sickening. Especially those last two, full of pompous platitudes about how much they support voting rights as they vote to kill them because the filibuster, the precious filibuster, this linchpin of democracy, which doesn't even exist in the House or in 33 state legislatures, this linchpin of democracy is more important than the basic functioning of democracy, which is the right to vote. There frankly needs to be a price, a political price to be paid for both of them. All right, so this is what I had, and I'm going to go with anyway. We start here on this wrap-up of news by noting that a new analysis by the Brennan Center for Justice finds that Copper state legislatures are showing no signs of slowing down what the report calls the tidal wave of restrictive voting legislation that we saw in 2021. That tsunami of bills involved 49 states, seeing a total of 440 laws restricting the right to vote that were introduced between January 1st and December 7th. 19 states passed 34 such laws, more than in any year since the Brennan Center began tracking these things 10 years ago. The group's analysis pointed to several categories of anti-voting restrictions, including restricting access to voting by mail, new or expanded voter ID requirements, the criminalization of ordinary lawful behavior by election officials who try to help voters, and laws allowing voter purges. It also highlighted what the center called a new trend, in which legislators introduce bills to allow partisan actors to interfere with election processes or even reject election results entirely. Now, that surely will continue in 2022. In at least 5 states, 6 bills have been pre-filed that aim to establish illegitimate partisan review boards of election results. Pre-filed here, the term means that they are already on record. These bills are going to be introduced in this year's legislative session in those states. Revealingly, the actual intention here, in case it wasn't already, 4 of those 6 bills focus on continuing reviews of the 2020 election results. And all of this being done in the name of election integrity, despite 0 states having found any evidence of any level of voter fraud worth mentioning. A big target of these attacks has been voting by mail. And there's every reason to expect that will continue in 2022. There are dozens of carryover bills, ones introduced last year but carried over to this year, that focus on restricting access to mail-in voting, ranging from shortening deadlines for applying for and delivering mail ballots to actually proposing criminal penalties for election officials who mail out unsolicited ballots, and even for individuals who assist voters, even handicapped ones, with returning mail ballots. In addition, there are at least 74 pre-filed bills in addition to those that I already mentioned earlier, assailing voting rights in various ways. At least 7 of these specifically target voting by mail, including eliminating reasons that are justifications for voting by mail, and expanding the grounds on which a submitted mail ballot can be rejected. These efforts are seeing results. Texas has one of the harshest laws attacking voting rights, one which, among other provisions, tightens the requirements for requesting an absentee ballot. Now, those are already hard to get. In fact, they're limited to a few categories, such as people 65 and older, people with disabilities, and people who will be out of their county for the entire period of early voting and election day. But one of the new demands is that the person making this request supply either their driver's license number or the last 4 digits of their Social Security number, which must match the number they supplied when they registered. Which not only means a single-digit mistake could wind up getting you denied your ability to vote, voters often face what Travis County Clerk Dana DeBovier called a guessing game, because they can't remember which number they used when they originally registered, which may have been decades earlier, and there's no easy way for them to find out which they used. The result has been that Travis County officials said that they have rejected about half of the requests for vote-by-mail applications they received. Harris County has rejected over a quarter, Bexar County nearly the same. And note that the primary in Texas here is in March, leaving little time for a voter even to first to find out they've got a problem and to find out what it is and to correct it. Oh, by the way, some other new restrictions in Texas are barring residents from obtaining applications for other people, including relatives and spouses, making it harder for voters with disabilities or language access barriers to get help, constraining election workers' ability to stop harassment or intimidation of voters by partisan poll watchers, and banning 24-hour and drive-through voting. Now, meanwhile, beyond this sort of legislative action, there has been action in the courts on related matters. In December, the NAACP and other civil rights groups filed suit in federal court looking to overturn South Carolina's new and gerrymandered map of its state legislative districts. They charged that the map was created in a flawed and non-transparent process, was done with a deliberate intent of disempowering black voters and solidifying GOPR control of the state legislature. The map used a mixture of packing, which is the practice of placing people of color all in one district in order to prevent them from having political power in any surrounding districts, and cracking, the splitting of communities of color among several districts in order to dilute their power in a given one. The idea is to find a proper mixture of packing and cracking that gives black South Carolina residents with as little power as possible. A similar story is playing out regarding Georgia, where voting rights groups and Georgia voters sued in federal court early in January, charging that 3 of the districts in the state newly drawn congressional map were packed and cracked to intentionally deny black communities in Georgia fair representation and so are unconstitutional. On the other hand, there was bad news out of North Carolina, where on January 11th, a 3-judge Superior Court panel ruled that the Republicans' newly drawn political districts, which will give GOPRs an edge in future elections, do not violate the state constitution, despite finding that the proposed districts are obviously drawn with and have heavy partisan advantage. Because as too often happens in cases like this, the judges threw up their hands and declared that redistricting is an inherently political process that does not impinge on the right to vote. Which in a way, I suppose it does in a very narrow, legalistic, individual sense. But it sure as hell impacts the right to fair representation, which is, after all, the point of voting. On the other hand, some of the news is even good, as there was a double victory in Ohio. On January 12th, the Ohio Supreme Court threw out GOPR-drawn state legislative district maps. A majority of the justices found that it violated the state constitution because it failed to draw legislative districts that correspond with the statewide voter preference of Ohioans. That is, they were gerrymandered for partisan advantage. Just 2 days later, that same court struck down the new GOPR-drawn map of congressional districts in the state on the same basis. That decision called the map infused with undue partisan bias, which perhaps explains, the judges went on, how a party, I'm quoting here, how a party that generally musters no more than 55% of the statewide popular vote is positioned to reliably win anywhere from 75 to 80% of the seats in the Ohio congressional delegation. By any rational measure, that skewed result just does not add up. Now, the advantage that voting rights advocates had here in Ohio is that Ohio voters in 2018 overwhelmingly, by 75 to 25, overwhelmingly approved an amendment to the state constitution intended to limit as much as possible partisanship in redistricting. So it's the all political dodge wasn't available to the court, and it was absolutely clear what the voters wanted done. All right, finally on this wrap for this time, a warning. There is a bipartisan proposal, assuming we can regard some agreement between Fishface McConnell and Joe Maniac as being bipartisan. But there is a bipartisan proposal to reform the 1887 Electoral Count Act. This is the one that's, despite having functioned quite well for 35 presidential elections, still had sufficient vagueness to be the basis for the claim that Vice President Mike Not Worth a Farthing could have overturned the vote of the Electoral College on his own authority or have thrown that vote to the House of Representatives. So there is the idea of reforming this so that we don't risk facing in 2024 what we almost faced in 2020, which is fine, absolutely fine. But beware of conservatives bearing compromises, because there is also a fear that such reform would be presented as a substitute for election law reform rather than an addition to it. That is, that the anti-voter faction in Congress would agree to this, agree to changing that bill, and then say, okay, we've dealt with election law reform, let's just move on. We can't let that happen. All right, I've got just a couple of minutes left here, so I'm going to wrap up with this. On January 14th, the Supreme Court agreed to hear an appeal from a high school football coach in Bremerton, Washington, who lost his job after defying school administrators by kneeling and praying at the 50-yard line after his team's games. The coach says the actions of the school board violated his rights to free speech and free exercise of religion. The board responded the school was entitled to require that employees refrain from public prayer to avoid the First Amendment's prohibition of government establishment of religion. Now, the Supreme Court declined to hear an earlier appeal of the case in 2019. 4 justices, Alito, Gorsuch, Kavanaugh, and Thomas, issued a statement questioning a preliminary ruling in favor of the school board from the Ninth Circuit Court of Appeals, saying that court's understanding of free speech rights of public school teachers is troubling and may justify review in the future. Okay, that future has come. Now the coach, this is actually quoted from the court record. The coach led the team in prayer in the locker room before each game, and some players began to join him for his post-game prayer too, where his practice ultimately evolved to include full-blown religious speeches to and prayers with players from both teams after the game, conducted while the players were still on the field and while fans remained in the stands. In other words, this guy was clearly on the clock. But that didn't matter to the dissenters at the Ninth Circuit, one of who wrote, again quoting, "It is axiomatic that teachers do not share their First Amendment protections at the schoolhouse gate." Yet the opinion in this case obliterates such constitutional protections by announcing a new rule that any speech by a public school teacher or coach, while on the clock and in earshot of others, is subject to plenary control by the government. But what really mattered to that judge, I'm prepared to promise you, and it surely will be to the sanctimonious SCOTUS 6, is that the speech involved was Christian prayer. I have no doubt that this case will ultimately come out in the coach's favor, and the right wing will celebrate madly. After which I will await the occasion of watching with bitter amusement the rapid shuffling of papers and redefinition of meanings when some public school teacher gets into trouble for hurting the fee-fees of some white students by discussing in class white privilege or present-day racism, and then turns around and says, hey, it's my freedom of speech, so nya can't touch me. The case involved, by the way, here is Kennedy v. Bremerton School District. And one last thing on this. Kelly Shackelford, the president of First Liberty Institute, which represents the coach, said in a statement, by taking this case, the Supreme Court can protect the right of every American to engage in private religious expression, including praying in public, without fear of punishment. So protect the private expression of public prayer. For his next trick, Kelly Shackelford will square a circle. Oh, one last thing. January 11th, Gitmo turned 20. Yes, it's still there. It's still open. There are still 38 people being held. That's it for this week. I'm out of here. We will see you in 2 weeks. In the meantime, have the best 2 weeks you possibly can. As always, peace.